Okay, so I think that means we should start. Dr. Ashwani Kumar, respected panelists in Geneva and India, and members of the audience. Justice Shah, who's just joined us. On behalf of CHRI, the Commonwealth Human Rights Initiative, and the World Organization Against Torture, OMCT, I welcome you to this webinar. June 26th is the International Day in support of victims of torture, and it marks the entry into force of the UN Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment, better known as UNCAT, in 1987. And it's an occasion to honor victims and survivors of torture, but also to raise awareness and promote concrete action to eradicate such practices, which still remain embedded in systems. India signed the UNCAT in 1997. That's 23 years ago, but it has neither ratified it till date, nor has it enacted a domestic anti-torture legislation. Today's webinar would look at best practices from across the world and the significance of the CAT, especially for India. For that purpose, we are privileged to have some remarkable resource persons, a star lineup with extensive experience in and knowledge of the issues. We are grateful that they have consented to share their perceptions, and we are grateful to be partnering with OMCT for this event. There are two sections to this afternoon. One is the international panel, as it were. Ambassador Nazat Khan, permanent representative of Fiji to the UN in Geneva. Dr. Alice Edwards, head of Secretariat for the Convention Against Torture Initiative, the intergovernmental agency. Gerald Staberrock, the Secretary General of OMCT. Dr. Ann Gallagher, the Director General of the Commonwealth Foundation. Dr. Ashwani Kumar, former Minister for Law and Justice in India and Supreme Court Senior Advocate, will be chairing. The second session, which is focused on India, we have three incredible, courageous, outspoken, and truly highly respected lawyers and human rights defenders. Colin Gonzales, Senior Advocate in the Supreme Court, Henry Tifange of People's Watch, and Professor Murthy, Registrar of Jindal Global University. The concluding keynote will be by one of India's most acclaimed and path-breaking jurists, Justice A.P. Shah, former chairman of the Law Commission and former Chief Justice of the Delhi High Court. Across the world, as we are aware, media reports, civil society, and research accounts show that custodial violence, torture, and third-degree methods are extensively used to coerce victims and detainees into making false confessions and statements, especially when they come from weak, poor, and vulnerable social groups. A recent example of state violence is the death of George Floyd in the US, which sparked worldwide condemnation of institutionalized discrimination and sparked demands also for police reforms. CHRI, the Commonwealth Human Rights Initiative, has been engaged in the prevention of torture in India and has advocated for UNCAT ratification and enactment of a comprehensive and effective anti-torture legislation for years. We developed in-depth analysis of the Prevention of Torture Bill in 2010, which passed in the lower house of parliament but lapsed in the upper house, and of the draft Prevention of Torture Bill in 2017, prepared by the Law Commission of India. In 2018, CHRI, in collaboration with OMCT and others, held an academic conference on strengthening legal protection against torture in India, bringing together various stakeholders, including CSOs, the NHRC, government, independent experts, and academics. That conference recommended the creation of an anti-torture civil society coalition in India. And in March this year, before the lockdown, we were able to organize the first meeting of this informal coalition, bringing together civil society organizations and independent experts to discuss advocacy strategies. This webinar celebrates the 33rd anniversary of the entry into force of the Convention Against Torture. It will explore how the convention contributes to the prevention of torture worldwide, challenges faced by India, the benefits of ratification and possible ways forward. I'd like to hand over the proceedings now to Dr. Ashwini Kumar, the former Law and Justice Minister of the Government of India and Senior Advocate of the Supreme Court, who will chair the first session. Let me introduce him briefly because he has a very formidable CV. Dr. Kumar has been one of the most vocal advocates of ratification, and we are honored by his presence. He was a member of the Upper House, the Rajya Sabha, for 14 consecutive years and held various ministerial positions, including Minister for Law and Justice. He was a special envoy of Prime Minister Manmohan Singh to Japan and the chairman of the Parliamentary Standing Committee on Science, Technology and Environment and Forests in 2015-16. He has also served as chairman of the Select Committee of the Upper House, the Rajya Sabha, for the Prevention of Torture Bill 2010. Dr. Kumar is a prolific author and has represented India at the highest forums of diplomacy, including the UNGA, the UNSC, and has also represented India at the World Economic Forum. Dr. Kumar, I hand it over to you. You'll make your initial remarks and introduce the speakers. Thank you.
Thank you very much, Sanjoy, for those flattering words of introduction. May I acknowledge with great respect the presence here of Honorable Justice A.P. Shah, distinguished members of at the podium, distinguished panelists, my colleague Colin Gonzales, and the audience. I would like to first and foremost thank the organizers for organizing this extremely important webinar on an extremely important subject. The time is opportune. The recent contexts in which we are continuing to see calculated assaults on human dignity mock the dignitarian and libertarian proclamations of many democracies across the world. I particularly refer to democracies because human rights, democracy, rule of law are intertwined, and I am not specifically referring to the failed and the semi-failed, the authoritarian, the dictatorial regimes across the world who neither do lip service to the cause of human dignity and neither do they remain committed as an instrument of policy to anything that would delegitimize torture. But since almost the entire world stands committed to eliminating this assault on human dignity, I think this webinar will serve a global purpose. It will serve a defining purpose that would determine the quality of democracies across the world and would either validate our claim that the world remains irrevocably committed to a civilized world in which there is no place for torture whatsoever. This subject, which we are going to be discussing today, apart from its broad framework, is specifically focused on the ratification of the UNCAT by the remaining countries of the world who have so far not ratified the convention. I would like to therefore mention very briefly my own experiences. There's something wrong with Is the voice clear now? No, there's still some disturbance. I don't know where that is. I believe it's voice over there. Can you hear me? It's at your. Is it clear now? Can I proceed?
Just getting a bit of an echo, but yeah. I think you can go ahead.
Can you hear me?
Yeah.
All right.
Ken,
That's what I was asking. So I was going to start with my own experiments with the ratification process. It was in 2010 that a select committee of Rajya Sabha was constituted by the chairman of the House, giving an express mandate to this committee to come up with a draft legislation for the prevention of torture. The occasion was the forthcoming visit to India of President Obama, and it was necessary for us to rededicate ourselves to a cause which our constitution mandates us for and which is ingrained inherently in our commitment to democracy, namely that we will not condone or in any manner encourage acts of custodial torture. And this was to be demonstrated because although we signed the convention in 1997, it is not till date that we have been able to ratify the convention, which baffles me no end and surprises me no end. So in 2010, we met over a 3 months period. That was the outer period given to us to come up with the draft legislation. And almost unanimously, we agreed to a draft. And I would like to tell you that the Select Committee of Parliament is a bipartisan committee on which representatives of all political parties are seated. It was with some effort, with some persuasion, but with a lot of goodwill on all sides that we were able to come up with what I believe was a comprehensive anti-custodial torture legislation. Unfortunately, between 2010 and 2013, because of various political developments in the country, this piece of legislation could not be presented for enactment to Parliament. Thereafter, there was a change of government. In 2014, a new government came in. And in 2015, I started writing letters to our distinguished Home Minister at that time, Mr. Rajnath Singh, and also to the Prime Minister and all concerned, that this being a non-partisan piece of legislation flowing directly from the constitutional mandate in Article 21, which guarantees to every citizen a right to life with dignity, this legislation should now be enacted because absence of a legislation against custodial torture was in the very least a gap in the law which was aiding custodial torture and not preventing it. Unfortunately, there was no movement at the level of the government. I was constrained in my own name to move to the Supreme Court of India, seeking just the exercise of the court's nudge or suggestive jurisdiction to advise and suggest to the government the advisability and desirability of passing this legislation as being essential instrument in aid of the constitutional mandate of Article 21. Surprisingly, regrettably, disappointingly, we were not able to persuade the Honorable Supreme Court even to exercise its nudge function of suggesting to the government the desirability of such a piece of legislation. The need for enacting this legislation grew out of our state practice that before ratification of an international instrument, we must have an aligned domestic law which would enable us to enforce the international legislation through our own domestic law. I'm aware of the fact that many countries have not taken the route. Many countries, including Fiji, including Nauru, including Denmark, including Maldives, have ratified the convention, and thereafter they started aligning their laws with the convention. Unfortunately, in India, our state practice by and large so far has been that we first have a domestic legislation and then we ratify the international instrument. But the procedural formalities apart, the fact remains that despite the Supreme Court of India having categorically declared in judgment after judgment that custodial torture is a wound in the soul, that it wounds the civilization. And every time human dignity is wounded, civilization takes a back seat and the flag of humanity flies half-mast. These are the words of the Supreme Court in D.K. Basu's judgment. And thereafter, in a number of cases, in Shabnam, in Jija Ghosh, in Romila Thapar, in Puttaswamy, in Nambi Nambiar, in all the recent landmark judgments, which I believe with all my heart are one of the finest judgments ever written by the Supreme Court of India, we still have not been able to persuade the highest and the most credible arbiter of constitutional conscience, the Apex Court of India, to even exercise its nudge jurisdiction. Personally speaking, as a lawyer, as a citizen, as an activist, as a person who has spent many years in public life, it has come as a great disappointment with the Supreme Court of India. It is not as if the Supreme Court has not exercised its nudge functions. Only very recently, in the case relating to mob lynchings, in a case relating to honor killings, and various other cases, the Supreme Court has suggested to the Parliament to bring in a law. All we needed was for the Supreme Court to exercise the weight of its moral authority and nudge the Parliament into action. Both executive inaction and legislative lassitude and judicial indifference has led us to a point where, despite a stellar track record of human rights jurisprudence encased in Article 21 of the Constitution, we have not been able to keep faith with the people of India and given to them a law that will help to preserve their dignity. If human dignity is a core constitutional value, non-negotiable and absolute, how can there be any justification for any democratic country run by any party not going ahead with a humanitarian and an enabling legislation in the advancement of human rights is the question that I repeatedly and on a daily basis ask myself. Even while we are speaking today, a leading television channel is running a program showing how police brutality on unarmed civilians has gone unaddressed and without redressal, despite a huge public outcry. I would also like to share with you one or two personal experiences, only to reinforce the absolute imperative of such a legislation. I had visited my constituency in the Punjab soon after taking over as a minister, and as per convention, the state administration receives the minister at the level of the head of the police and head of the administration of a district. On this visit, I was also received by the administration, and there was a person in the crowd which had come to greet me and receive me, who was standing all by himself, distraught, an elderly figure with wrinkles on his face, unconcerned with the rest of the commotion around him. His face bore a picture of extreme agony, grief, desperation, and desolation. I noticed his presence, and I asked one of my secretaries to find out what his problem was. And I was told that he wanted to personally have a word with me. And he came to me and he said, I had two sons. One of my sons has been killed in a police encounter already. The other son is in the custody of the police and is being inflicted with third-degree methods. And only hope that he's not dead by now. I've come to you considering that you are sensitive about these matters, to find out whether you can be of any help. I did call up the Senior Superintendent of Police. He did confirm that the gentleman was in the custody of the police. I told him, whatever investigation you need, you go ahead with it. But for heaven's sake, do not use third-degree methods. It is not permitted by law. He promised to call me back in half an hour. He did call me back in half an hour. He said, you are right. And sir, he said, you know the ways of the police. You have been in politics for a very long time. We have our limitations, but I have, after your call, personally investigated the matter. The boy is without a fault, and I have ordered his release. He was released, he was saved, but not before he was badly beaten up. Very, very badly beaten up and mauled. Apart from the physical torture, this kind of treatment leaves a scar that never heals. And I do want to finish my initial remarks and conclude by just quoting Adriana Barton, who said, torture is a wound so intangible that there is no way to heal it. It leaves a permanent scar, not only on the person's psyche, but also on his heart. And it certainly scars the conscience of a dignitarian democracy, such as India. I've always believed that more than anything else, the Indian Constitution promises a dignitarian democracy with freedom, liberty, dignity, and equality at its core. In my experience in public life, I have noticed that equality is still a chimera. It is still a mirage. Rule of law premised on equality does not function in the same way for everyone, as has been amply demonstrated. But I have no doubt that the consciousness of the nation will assert and continue to assert till such time that we have an effective and purposive law on our statute book, which will enable us to ratify the UN Convention. India does not deserve to be standing alone with semi-failed and failed states and dictatorial regimes who have not signed and ratified the convention. India deserves better. India must do better. India is expected to do better, and we remain committed to ensuring that India becomes a part of the international regime that has ratified the convention, that applies international standards to its own laws, as we are indeed obliged by Article 51C of our Constitution to do. And I, as a civil society, as a citizen of this great country, as a lawyer and as someone long years in public life, pledge and dedicate myself to continuing this fight for an effective, standalone, anti-custodial torture legislation in India and to the ratification of the UNCAT. Thank you very much.
Thank you, Dr. Kumar. Would you like to introduce the next speaker, because you are chairing the session now?
Yes. The line is not clear.
The eloquence carried all of us away. But he's here now.
Who would be the first to go? Because that line has been blurred. If you can just tell me the sequence.
I think it's Ambassador Khan.
Ambassador Khan, you have the floor. Thank you very much, Ambassador Khan, for joining us. And before you say something, just a word about Fiji. Fiji has taken a remarkable initiative in putting together a group of regional countries to come forth. It was done recently, I think in January, and persuading the smaller island states in the Pacific to ratify the UN Convention. So thank you very much for joining us.
Thank you very much indeed, Excellencies and ladies and gentlemen. And thank you very much, Sanjoy, for organizing this and putting us all together virtually. And thank you also for inviting me to participate in this important event. As you quite rightly say, Dr. Kumar, Fiji is one of the states of the Convention of Torture Initiatives, which is an organization an organization which is committed to universal ratification of UNCAT and uses particular states as champions, really, towards universal ratification. So I want to speak a little bit about Fiji's journey to ratification and some of the challenges we've had in relation to both ratification and implementation, so that it is helpful in this conversation. Fiji did not ratify UNCAT until 2016. And I think that the reasons were partly because Fiji did not have a mission in Geneva until 2014. It also had a new constitutional framework in 2013, which defined torture more broadly than Article 1 of UNCAT. So what is envisaged in Fiji's definition of torture is specifically also psychological and emotional torture in addition to physical, but it also is wide enough to encompass torture which is perpetuated by the private sector, as well as at home and at school, and the perpetrator does not have to be an agent of the state. So it's a broader definition. And when we were considering ratification, one of the questions that Capital kept asking is, how is ratification going to sit with our domestic legal framework? Are we going to have to shortchange ourselves and water down our definitions of torture? And is it possible to ratify side by side with a much broader domestic framework? So that was one of the things that really we were interested in discussing. Thirdly, one of the reasons why we did not ratify is because I think we didn't really focus on the question of why we should ratify earlier. And one of the mechanisms that really encouraged us to focus on the question was the UPR mechanism. So Fiji had its second cycle UPR in 2014, and many states, including CTI core states, recommended that we consider ratifying UNCAT. And of course, once that recommendation is made from the floor, the reviewed state must consider it in a process of, I think, navel gazing, a lot of anguished discussions privately with the delegation which comes from Capital, and also discussions with organizations like CTI and the Association for the Prevention of Torture. And I really do take my hat off to the Association for the Prevention of Torture, because as soon as they heard that we had opened a mission in Geneva, they were the first in the queue of organizations wanting to speak to our minister about ratification. That is how important they thought it was, and we were really lucky to have that kind of briefing almost immediately after we opened our mission. So I think there was a sense of lack of familiarity with UNCAT. There was a concern that we would have to water down our domestic framework and that our laws did not conform to what UNCAT expected of us. And finally, that we would have to change too much too soon, especially after this new constitutional framework in Fiji. Having discussed this at length with the experts in Geneva, we realized, in fact, that our fears were not grounded on any kind of reality, because ratification was going to help Fiji in its journey to removing the risk of torture in all of our processes, particularly our legal processes. And also the discussion we had here in Geneva and also in Suva, those discussions were centered around how can ratification help us? How can they help the police force to really revitalize its own processes? I mean, we are a country which still has the judges' rules that we inherited from the British. And so therefore the admissibility of confessions in court depended on the old test of voluntariness. Despite the fact that we have this old test of voluntariness, nevertheless, obviously torture is an impediment to admissibility. So we realized quite quickly three things. One is that by ratifying, we would have access to a lot of technical assistance, both in Geneva and at Capital. And there are several countries which have indicated their willingness to work with Fiji on eradicating the risk of torture in our internal processes. Secondly, ratification did not mean that we would have to have a battle with our domestic law. Because, you know, you don't overnight change your processes. You ratify, and then you review your processes to see how you can bring your domestic framework in line. And it did not mean that we had to change our constitution at all. In fact, by ratifying UNCAT, which had a narrower definition of what torture was, it was easier for Fiji. And the third thing we realized, which really persuaded us towards ratification, is how helpful this was going to be for the bar and the bench. Fiji already has a provision in the Constitution which says that in the interpretation of the Bill of Rights, the courts can look at international law to help them in this interpretation. Some courts have looked at unratified conventions to help them to ratify rights which are in the Constitution and which obviously came from a source which came from the unratified convention. For instance, most of the rights in our Bill of Rights were ICCP rights long before we ratified ICCPR. But it makes it easier for courts to implement anti-torture laws if we have ratified UNCAT. There was no doubt about it at all. So that really was the third reason. We knew that this was going to be helpful for the way that torture was looked at by the courts and the way in which our laws would be interpreted in relation to anti-torture mechanisms. So then we ratified in 2016, having made the commitment in 2014 at our UPR. But then came the enormous challenge of working out a path of implementation. And immediately we realized that we had a lot of work to do with our police force. Because as long as police procedures lack transparency, and inevitably they do, I mean, police forces are not a charitable organization or some kind of theater group. Much of their work is done behind closed doors. But that lack of transparency creates a risk of torture and of police abuse of power. And we knew that and we acknowledged that. So therefore, ensuring that the police force was part of this journey of ratification and implementation became extremely important. We looked at the rights of persons to counsel as an important mechanism for protecting people from torture. The sooner a lawyer can come to the police station to talk to his or her client, the less likely it is that that particular client is going to be subjected to police misbehavior. And we knew this. So then why were so many accused persons opting not to have counsel at the police station? That was mysterious. I've said before, it's a bit like a drowning person who's being thrown a plank who says, no, thank you, I don't want the plank. It's extraordinary. So how were we going to look to implement UNCAT in a way where we could work with other partners to looking at processes which would better protect the rights of persons to counsel at the police station? And we work with Switzerland to implement first hour procedure in Fiji, which is that within the first hour of arrest, the police must call a lawyer to the police station. It's not an option. The accused is not opting. This is something the police must do. And it is a service which is provided free of charge by the Legal Aid Commission. And until that lawyer comes to the police station, the police must hold off on interview. We discovered that in this journey of implementing UNCAT. And because we are already here in Switzerland, Switzerland was a very logical partner. But then subsequently, the European Union, which already had launched an access to justice program in Fiji, was very pleased to incorporate first hour procedure in Fiji and help us to implement this effectively in all our police stations. So another example of how we were able to implement UNCAT, and I have to say that we're not even pretending that we're there. We've got a lot of hard work to do. For every 2 steps forward, we find that, you know, we have to take 1 step back because some awful incident has been reported in the media that the police are not, in fact, complying with this procedure or that procedure. Nevertheless, I see implementation as a journey, a trajectory. And so another really important part of this implementation was to ensure that the police had ownership. So from the time of ratification, we worked very closely with the Commissioner of Police. This required political leadership from the top. And we organized side events here in Geneva, and we invited the Commissioner of Police and the Chief Justice to Geneva to talk about gaps in anti-torture laws in Fiji and talk about how ratification and implementation of UNCAT would help Fiji in this journey. It required a high degree of honesty. Again, we could not pretend that we were a perfect country if we were going to make any difference at all. And so therefore, making sure that the judiciary and the police force and the bar had ownership over implementation became very important. And when they came to Geneva and they connected with, for instance, the Convention on Torture Initiatives, which chaired 2 of our side events, and Dr. Alice is here, and she was the one who actually chaired the last one. When they chaired it, they felt a sense of ownership. They were part of this international move towards an effective implementation of UNCAT. The third area, which we almost immediately got onto, was the risks of torture in prison. Again, an institution which by its very nature lacks transparency. So therefore there is an accompanying risk of torture. And we identified UNODC with its Nelson Mandela rules work as a good partner for our Commissioner of Prisons, whom we brought to Geneva, and who worked then with UNODC and continues to work with UNODC in including the Nelson Mandela minimum standard rules on the treatment of prisoners into the prison regulations in Fiji. So what of the future? We still have to work on the creation of an offense of torture. We have a series of offenses in our Crimes Act, which talk about assault and different types of assault, but we don't have a specific offense of torture. So we need to work on that for future law reform. We also need to work on continuing to change the mindset of the police. It's wonderful that the Commissioner of Police is very committed to implementing UNCAT, but he doesn't control every police station. And it's the middle management of the police force that now continues to be work in progress for Fiji. Another is the incorporation of UNCAT into all our police manuals and all police conduct, so that police recruits from day one know what ratifying UNCAT means and how that must change the conduct of police officers at stations. And also, very, very importantly, working with other Pacific Island countries to encourage ratification in the Pacific. The Pacific continues to be a region with unrepresentative under ratification. And again, I think much of that is a lack of familiarity with what it means to ratify. And the fact that you don't have to, change your constitution overnight by ratifying, that's not what it means. But what it does mean is you have access to partnerships and technical assistance, which a country needs in order to eradicate the risk of torture from all its institutions. So I really appreciate the opportunity to speak at today's event. And in relation to Fiji's journey, I'm sure many countries can empathize with what were impediments to our initially ratifying, and how we found that with the familiarity of ratification and implementation, how we found that our fears were groundless, that in fact this was one of the most positive steps that a country could take in ratifying UNCAT, and how much we have benefited from being able to work with partners on effective implementation. Still work in progress. Thank you very much indeed, Dr. Kumar.
Thank you, Ambassador Khan. It was an excellent and a compelling presentation, and I think you've more than convinced the audiences. You've certainly convinced me that we don't have to wait for domestic procedures before becoming a part of an international movement in a very noble cause. You also very eloquently express the role of political leadership. And that, I think, is the key. Because until the political leadership is convinced of the urgency of this initiative, I fear many countries, as democratic as India, will be accused of delay in becoming a part of an international regime. I would now like to call on Dr. Alice Edwards to give her opening remarks. Your leadership on the subject is well known on behalf not only of the Commonwealth, but also the rest of the world, which values human rights, which knows that torture in any form, anywhere, for any reason, is incompatible with human dignity. Your services to this cause are much appreciated, and I'm delighted that you do us the honor of being with us today. The floor is yours, Dr. Alice, please.
Thank you very much, Dr. Kumar. Also, greetings, Judge Shah, Ambassador Khan, eminent panelists, and everyone joining online. Thank you to the Commonwealth Human Rights Initiative and OMCT for the invitation and opportunity to engage in this important discussion, particularly apt as this is the week of the UN's Day in support of victims of torture, which we commemorate this Friday, the 26th of June. It is a great honor. CTI, the Convention Against Torture Initiative, has for the past 5 or so years been assisting states in all regions to ratify the Convention Against Torture and to take action to review and reform national laws, policies, procedures, and practices. In this short period, an impressive 16 new states have ratified the Convention, making it one of the fastest moving of all the human rights treaties, and it is poised to reach global ratification by our deadline, 2024, coinciding with the Convention's 40th anniversary. Also over this period, hundreds of government officials and other stakeholders from 140 plus countries have participated in CTI events, seminars, and visits, organized in the spirit of the initiative, which involves peer-to-peer, confidential and constructive, that is, no name, no shame dialogue. We offer closed-door forums for states to share their experiences, challenges, and successes. CTI has conducted diplomatic visits to 10 countries, hosted delegations to Geneva, and developed a repository of practical tools that showcase at last count 180 plus good and innovative examples of how states are implementing the convention. CTI is a unique cross-regional endeavor born from the commitment of 6 governments, and these are Chile, Denmark, Ghana, Indonesia, Morocco, and Fiji. And I'm pleased that Ambassador Khan has shared her country's experiences of the process towards ratification and now their phased implementation and the many benefits and opportunities it has brought. This state-led approach has been particularly effective in opening doors, including with those that may be reluctant to engage with international organizations or outsiders. An additional 40 plus governments, international and regional organizations, leading anti-torture NGOs, and experts form the CTI group of friends. And the CTI Secretariat, which I head and is based in Geneva, is available, and we provide technical advice and capacity building assistance and run CTI's annual program of events and activities. The Prohibition Against Torture is a jus cogens norm of international law. The Convention does not create a new obligation on states to prohibit torture. That obligation already exists as global custom. Rather, it is an instrument geared to assisting states step by providing a framework of building blocks for a robust and fair system of justice and governance, respecting the rule of law over might and with checks and balances to guard against excesses. The key words in the treaty could perhaps be summarized as preventing, training, reviewing, criminalizing, accountability, and protecting rights of victims. So why ratify the Convention Against Torture? Ratifying the convention in some countries has launched the country onto a path of nonviolence and reconciliation from past harms. For others, it has prompted much needed and welcomed reforms, leading to fairer, dignified, and state-of-the-art policing and law enforcement and criminal justice systems. For yet others, it has led to tangible benefits, such as decongesting of overcrowded prisons, fewer scandals and complaints against the authorities, and enhanced trust and reputation between state authorities and the citizens they serve. Being party to UNCAT also facilitates extradition between states parties and encourages coordination and mutual legal assistance between them, removing one of the barriers to the transfer and prosecution of accused suspects. This relates not only to those wanted for the crime of torture, but also persons suspected of serious criminal activity. Legislative stocktaking, both prior to and post-ratification, has been undertaken by many states. In CTI's view, and also as the experience of Fiji shows, there is no requirement for an entirely compatible legislative framework to be in place ahead of ratification. This has launched the country onto a path of non-violence and keeping laws under review is an ongoing and normal function of government, which is therefore, and perhaps unsatisfactorily, always an unfinished project. That said, CTI encourages states to undertake a gaps analysis and to plan for and to commit to legislative reform where necessary as an important strategy for implementation. I appreciate what has been said today about the Indian approach to adopt legislation in advance of ratification, as well as Fiji's experience where they have considered the legislative review part as a subsequent tiered approach to their own implementation. Different states adopt different practices. Through legislative review processes, UNCAT has helped countries abolish and rewrite old colonial laws that mandated hurt and suffering, for example, in the treatment of prisoners. It has guided states to update laws that no longer reflect modern law enforcement approaches, or in fact, which fail to match realities on the ground. CTI and the Association for the Prevention of Torture published an anti-torture legislation guide to assist governments to get ready for ratification and implementation of the convention. And we were pleased actually to host a judge from the Indian Law Commission at a technical workshop on anti-torture legislation in 2017. What causes torture and how do we respond to it? Individuals who abuse their position of authority are only one part of a complex bureaucracy. Approaches to preventing torture and such misconduct need to address all aspects that contribute to the overall environment that permits such practices to occur and should be properly located within broader processes and structures governing the rule of law and the administration of justice. Research explains that a combination of political, economic, legal, cultural, and social processes and structures can create the conditions conducive to such behaviors as coercion, intimidation, or corruption. Evidence also shows, unfortunately, that the poorest and most vulnerable members of society are at heightened risk of ill treatment. On the other hand, today we are well equipped with understanding what causes and incentivizes torture and similar abuses, and there are a wide array of good experiences on how to change mindsets, reduce risks, and respond appropriately to incidents prior to them becoming institutionalized behaviors. In building torture-proof societies where people are treated with dignity, the rule of law and orderly conduct flourish and risks are minimized, the UN Convention Against Torture can really assist. As the CTI core states always say, no state is perfect, but all states could do better. They are united against torture as a universally recognized ultra vires act and are committed to continuous improvements in their systems and societies. To welcome India as a state party to UNCAT, home to 1.3 billion people, or nearly 18% of the world's inhabitants, would be an extremely important signal, both home and abroad. only 25 countries are left to ratify the convention, a rapidly shrinking number. We know the Indian government and people do not support torture or ill treatment, and we appreciate the government's recent commitments and pledges to ratify the convention. To end, just to say that CTI offers its full support to the Government of India in its deliberations and action towards ratifying this fundamental human rights treaty. Thank you, Dr. Kumar.
Thank you very much. May I go straight away now to our next speaker in view of paucity of time? This would be Mr. Steberok of OMCT, widely respected for his research and advocacy on matters related to torture, Secretary General of an extremely important organization. You have the floor, Mr. Steberok.
Thank you, Dr. Kumar. And thank you to the Commonwealth Initiative for spearheading this important event and following up, as Sanjay has said this morning with the introduction, on an event we had with an academic conference about 2 years ago discussing the ratification of the Convention Against Torture. And I'm pleased to see that this journey that started 2 years ago takes another step of a journey, which hopefully will us all coming to promised land of ratification very soon. I'm speaking from the perspective, maybe a little bit different, from a perspective of a civil society network, the Global Coalition Against Torture, with network members across the world. And I'm speaking from a perspective centrally coordinating and mobilizing civil society to use the implementation processes that the UNCAT ratification would bring to India, the process with the Committee Against Torture, to have this continuous improvement of laws, policies, and practices. I'm particularly pleased to be here and to speak about why India should ratify. At the same time, I feel it's also a paradox. And I want to start with a confession here. And I know that confessions are always something a little bit dodgy and dangerous when we speak about torture prevention. As a young student, I had the pleasure of doing an internship at the United Nations, seeing Justice Bhagwati in action in the Human Rights Committee, seeing how Indian personalities and judges were framing international law, were progressing international law. As a young student fascinated by international law, I read Indian jurisprudence, quoting the CEDAW Convention and others. So in some way, I feel a little bit odd that I'm to tell you why to ratify with this proud history in India on the rule of law, legal precedents, and the use of international law domestically. And I add to this a second paradox, which I think is one of the first reasons why ratification is effectively needed. And maybe it's obvious, but often we don't say it. We have a paradox that on one side, torture is prohibited, and all my previous speakers spoke to the fact that it's part of Indian law, that it's part of customary law, it's part of what we call a jus cogens erga omnes, the highest category of international law. You've ratified the International Covenant on Civil and Political Rights. The legal obligation as a base is already there. But torture remains a ground reality in India as in other parts of the world. And Dr. Kumar, you mentioned the recent experience. We have seen in this COVID period around the world, again, that the most vulnerable are more subject to abuse by law enforcement. That torture is a reality, that judicial remand means for many people in Asia and elsewhere, a likelihood of abuse. So I think the ratification is to tackle that problem and that paradox between what is legally required and what the ground reality is. And here comes, as a second point, the real added value of the Convention Against Torture, because it is a guidepost, it is a tool for this journey of improving our systems and to making that gap between law and reality smaller. This is our experience we have on the ground working on torture with civil society organizations, engaging governments, but also in using the processes that the Convention Against Torture itself provides. And in this, I think we have to go back to another point that is quite important and makes it understandable why this convention is needed. We have many human rights issues, and sometimes we list them in a long laundry list of different issues. But I always say torture is different. Torture is not, in inverted commas, just a normal human rights violation. For one, as Dr. Kumar said in the beginning, it leaves traces for life with people. It destroys the personality and the integrity of people. It destroys communities and societies. It leaves traces to the rule of law. It prevents development. It is like a cancer disease in society. And I think it is in that sense really one of the most foundational notions of who we are and what our society and our rule of law is. Then I think also the ground reality is that writing a law and saying torture is prohibited will not work alone. We do know that security forces all over the world have a core spirit where they defend each other. We do know that it takes more to make remedies work on torture. We do know that victims need protection. We do know that it takes more to translate a torture prohibition into the reality of prison life. And this is what the convention tries to do. It's a light path to the types of reforms that we need to see to bridge this gap between a prohibition and reality. In this regard, I also want to say one thing that is very important to me and also to civil society. I know you have a strong rule of law, which is a precondition for using international conventions effectively. I think if the ratification follows, the fact of judicial use of the convention in India would be a surplus, a very strong surplus on protection. But also, the convention allows a dialogue on institutional reforms that are needed. And we've seen this in Fiji and in the presentation previously. Prison reform agendas, police reform agendas, a whole movement about victim rehabilitation and support have all been born out of the Convention Against Torture in many countries. And this leads me to the point that I think was very centrally made by my previous speakers about the continuity of process. The convention actually provides a reporting process every couple of years to a committee against torture. When we read this, we sometimes take it as an administrative bureaucratic exercise. When we work on it and live it, it actually is a constant review because we're never perfect. Things change, our politics change, our societies change, our understanding of issues changes. And it allows, if we use this tool effectively, a constant review and improvement and reform agenda to keep the torture issue on the agenda. And this is, I think, my big point that I wanted to make. CAT ratification works. It improves the situation. It is about ratification and bringing a convention home that should be home already. But it is also about the process of protecting victims. It is also about the process of engaging in dialogue with state institutions on torture. It is also about empowering civil society. When we look at the question, when do conventions have a real impact on the life of a nation and the legal systems domestically? It is ratification, it's political transition, but it is very much that it provides a platform for state and non-state actors to unite on torture, on the fight against torture. It legitimizes demands for a more equitable, fair, just legal and institutional system. We've seen this with a Women's Rights Convention. We wouldn't have a women's rights movement without a CEDAW convention the same way. We see it today with the Disabilities Convention globally, and we see it with the Convention Against Torture. This is why my appeal is also that ratification is the first step in a journey, but it is also a constituency building of people who want to see change, who engage on the basis of the convention, be it in civil society through a coalition that the Commonwealth Human Rights Initiative has formed, be it in enlightened government, be it in the good forces in law enforcement, that we need to give the force and the strength to come out as forces for change. So this is what I wanted to say. The Convention Against Torture works. I think it will improve the situation. It will reduce the paradox that I laid out in the beginning. And of course, it is evident that India's ratification would have also an important signal to the global anti-torture movement. We see you as part of the global anti-torture movement, and it's time to overcome this paradox and to walk into the room. I've learned from my father, who always said, sometimes you have to jump. Perfection can be the enemy of progress. I think the time has come to make the jump and see where it takes us and ratify, so that it doesn't become an endless waiting game, but a journey that we can all enjoy together. Thank you.
Well, thank you, Mr. Sebrok, for a very illuminating remarks. It is a given that the UNCAT provides a comprehensive, even though minimal, framework for action by nation states. And I think it provides an extremely useful starting point. And that is the case we had made out, that we need a comprehensive law against torture, not a mere tinkering with the definition of torture here or there, because it is a complete set of an ecosystem which enables us to prevent torture. It is now my pleasure to invite Dr. Ann Gallagher, the Director General of Commonwealth Foundation, who has had an extremely important role in advancing the issue of custodial torture and in getting a whole lot of civil society organizations on board, a whole lot of people on board who have strengthened the movement for the abolition of custodial torture. You have the floor, Dr. Gallagher.
Thank you very much, Mr. Chair, and my thanks to CHRI for inviting me to be part of this panel. In some ways, it feels like completing a circle. My professional career really began at the UN, working on human rights almost 30 years ago. And I did want to take us back to that time because I think it provides some important lessons and insights for us right now. None of us realized back then, but the 1990s were in many ways a time of flourishing and growth for the international human rights movement. A complex web of treaties backed up by independent oversight bodies provided that system with both structure and strength. For all its failings, the UN's Human Rights Commission, as the council was back then, often worked well in highlighting egregious abuses and holding governments to account. And this was the time of unprecedented developments that could never have been imagined, even a few years before. One example that stayed in my mind is the establishment of international courts and tribunals to bring individual perpetrators of human rights abuses to account. Something that I, as a student of international law just a few years previously, had never, ever imagined possible. And the 1990s also saw a decisive shift from the margins to the mainstream, a growing recognition that across the UN, from peacekeeping to development, human rights needed to become part of how we thought and how we worked. Back then, we really understood on a deeper level the idea of human rights, had the power, the potential to transform human relations by shifting power from those who had too much to those who didn't have enough, from the state to its citizens, from men to women, from adults to children, from those who, because of their race or their ethnicity, had more power than to those who, for the same reasons, didn't have enough. Human rights were indeed putting words in the mouths of the powerless, amplifying the still small voice that called for dignity and for justice. Of course, things were far from perfect. The idea that women's rights are human rights, for example, something that we take as a given today, was so radical in the mid-1990s that it actually had to be said. Protection from discrimination on the basis of gender was not even spoken about. And we knew deep down, even back then, that political support for stronger human rights protections in some areas, for example, in relation to migrants, would always prove elusive. Now, one certainty that we shared back in the 1990s was the conviction that the war against torture had largely been won. Now, of course, we were not so foolish as to believe that torture itself had been eliminated. I remember in my mid-20s traveling to countries of the newly liberated Eastern Europe with members of the UN's Torture Committee as they explained to genuinely baffled police officials that their routine policing practices were unlawful under international law, and because their country had just ratified the Convention Against Torture under national law as well. This was the time of the Balkan conflict, the Rwanda genocide, the time of large-scale disappearances and political killings from Asia to South America. In In many ways, it was as ugly and divisive then as it is today. But the prohibition against torture, breached so often, appeared to stand apart above all of this. It was indeed widely recognised as a superior norm of international law. States may violate the norm, but they would always pretend that they hadn't. States would never, ever try to justify such violations. Today, the international legal prohibition against torture appears slightly less polished. If it were a car, it would be covered in dents and scratches. I strongly believe, I must believe, that the core of the norm, the engine, remains sound. But it has weathered damage over the past years as states, including those that have traditionally led the international human rights movement, have seen fit not just to violate the prohibition against torture, but also to question its essential validity. Standing up to this assault is the Convention Against Torture, an international instrument that for this human rights lawyer is beautiful in its simplicity. The convention describes exactly, perfectly, what torture actually is. It then says that torture is never, ever okay. It clearly sets out what states need to do to respond to torture when it happens. It then details how states can make the act of committing torture as difficult as possible. Finally, the convention requires its states parties to come to an independent body and explain just what they are doing. That's pretty much it. Nothing vague, nothing extra. The perfect human rights treaty. Today, I'm leading one of the Commonwealth's 3 intergovernmental agencies, a world that seems far away from the international human rights system. But I've found the overlaps and synergies are profound. The Commonwealth is ultimately built on a recognition of the value of the human person. Our Constitution, our Charter, recognises that human rights are fundamental to what it means to be a citizen of the Commonwealth. The Charter places human rights front and centre of the Commonwealth project and the Commonwealth identity. I quote, this is from the Charter, "We are committed to the Universal Declaration of Human Rights and other human rights covenants and international instruments. We are committed to equality and respect for the protection and promotion of human rights for all, without discrimination on any grounds, as the foundation of peace, justice, and stable societies. We note that these rights are universal, indivisible, interdependent, and interrelated, and cannot be implemented selectively. We are implacably opposed to all forms of discrimination." Ladies and gentlemen, ratification of the Convention Against Torture is, by Commonwealth countries, I believe, an affirmation of these lofty ideals that our countries treasure. Ratification should, in my view, always be unequivocal and without reservation. There will always be some reason for equivocation, but reservations, especially to this instrument, are deeply worrying. They become, over time, scratches and dents that damage the integrity of the norm. But we should also remind ourselves that ratification, while necessary, will always be insufficient. Perhaps more so than other human rights norms, effective implementation of the prohibition against torture requires that it be absorbed internally, that it becomes part of the fabric of society. Effective implementation requires a change in the social contract. It requires that everyone, from the police official to the private citizen, accept as legitimate a new standard of relations between the state and its citizens. This will always be the hard part. Ladies and gentlemen, I close with what has always been to me the most eloquent and expansive expression of what human rights are and why they are important. Listen carefully. These 2 lines that begin the Universal Declaration of Human Rights are as urgent as relevant today as they were back in 1948. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. This precious idea is quite simply the reason that we're here. Thank you so much.
Thank you, Dr. Gallagher. That was indeed a compelling case for the ratification. It was, of course, premised on an equally compelling and unexceptionable proposition that there is an absolute right not to be tortured and an absolute right against torture that admits of absolutely no exceptions. In fact, I'm reminded of what I read some years ago, Professor Louis Henkin. He said that the only political moral idea that has received universal acceptance is the idea of human rights, idea of the right not to be tortured, not to have one's mental and bodily integrity violated. But it is also true to me, as I listen to the eloquent speakers, that while a lot has been done, this journey is as yet incomplete. We will need to organize mass opinion to spur political leadership of different countries into action, indeed to spur global political leadership into action before the promise of democracy is realized for the peoples across the world. I now have one question which we need to discuss, and I think the question which, with your permission, I would like to read out is as follows. Would the CTI have examples of good practice after ratification and how it has helped development of domestic legislation in their experience, particularly in the face of complicated constitutional processes? I think the case of Fiji is a perfect example. Perhaps Dr. Edwards could answer, or?
Thank you, Dr. Kumar. I think I understand the question to be how we have helped governments in this domain. The main methodology, I guess, of the CTI is actually to bring governments together so that governments share their experiences. And that is a way in which they can, especially common law countries in particular, is a way we have done this. In Africa, we've had, following on from an event in Accra, which brought together Francophone, Lusophone, and Anglophone African countries. The countries requested further information and technical advice on how to reform national laws. And I think, and we went on to hold events in Entebbe and for common law countries and also in Dakar for Francophonie. Later this year, we will be running a similar workshop in the Caribbean, and subsequently next year, because of coronavirus and other challenges to travel in the Pacific. In relation to Asia, worth pointing out that as a follow-up to a Bali seminar we held in November, hosted by the government of Indonesia, there have been discussions about the need across the Asian region also to look into legislative reform. I think what we've learned from that is that, I mean, the starting point is the constitution, and we shouldn't forget that many countries already have robust provisions. And as Dr. Kumar mentioned in relation to India, Article 21, as well as other articles in the constitution, do start and are the founding basis for the rest of the legal system. And so the legislative framework, there are two approaches mostly adopted by states, either a standalone anti-torture law, or alternatively to amend relevant pieces of legislation. And states have taken different approaches to this. Those countries that, for example, are emerging from a history of torture and oppression and dictatorship have generally opted to go for a standalone legislation. They want to make a statement that this is significant for the country and that they want to make a change with the past. Other countries have, and of course there are also countries, democracies, Australia, New Zealand, who have also adopted more standalone criminal legislation as opposed to the full spectrum of what the convention covers, which does go beyond criminal law, although that's clearly one of its key focuses. Other countries have opted to kind of review all of their legislation and to make adjustments, for example, to the criminal law specifically, or to the police acts and the prisons acts. And I think regardless of which approach one takes, that wholesale review is necessary. And more recently, CTI has been gathering information on different states where, in fact, very strong anti-torture statements are found in prisons acts or regulations, or in police and law enforcement, or in defense laws. And I think that's important to understand, that in fact the torture, the anti-torture sentiment and prohibition needs to be in all the laws where it is necessary. And that's why I say I think it's always an incomplete process ahead of ratification. No country is really able to, at the point of ratification, say, we have everything in place. Only in the last 10 or so years has the Committee Against Torture really been looking at torture in the context of psychiatric institutions or hospitals or old age homes. Now, when many countries ratified early on, these were not on their radar as sites of potential harm. And I think, therefore, a bit echoing the words of Gerard, you know, there is this perfect being the evil of the good. And what we've seen is that taking the step of ratification really can launch these more comprehensive reviews. I think I'll stop there unless there are other questions. I could say a lot more, but I'll stop.
Thank you very much, Dr. Edwards. I have a question directed at me, which is in two parts, and I'll quickly answer. One is, why am I optimistic that India will ratify CHRI? Well, the first part of my answer is that I'm naturally optimistic, and I believe in righteousness prevailing sooner or later, and I have absolutely no reason to discount that belief as far as the anti-custodial torture legislation in the future is concerned. And I also have a very good reason, and the reason is as follows. We have had a select committee of parliament, which represents the aspirations and the sentiments of the people at the highest level, which has supported such a legislation. The Law Commission of India has supported this legislation. The Human Rights Commission of India, in an affidavit filed in my petition in the court, has supported this legislation. And the 2017 recommendation of the Law Commission, which was post the hearing of our petition, our matter, or during the course of the hearing, I beg your pardon, has categorically supported such a law. There's also a draft law prepared during this government's tenure, which supports the anti-torture legislation. There's an evolving, dynamic, progressive, irrepressible human rights jurisprudence in this country, which mandates that the spirit of Article 21 be respected. If there's consensus in this country on one point, it is on the question of right to life with dignity, which is now no longer in the realm of conjecture. The right is an ever-expanding right, and the Supreme Court, through a process of interpretative deduction, has derived many rights, including the right not to be tortured. So when all organs of the government at some level or the other are supportive of it, when public opinion is supportive of it, when the reality on the ground demands it, when the dignitarian politics to which we profess and which we claim is ours for proclamation in the world, we have no option but to bring in a strong anti-custodial domestic legislation, which will enable us then to ratify the convention. The second point was why ratify the convention, bring in a strong domestic law. Now, if we bring a strong domestic law, there's no reason for us not to ratify the convention. That way, we tell the world that we are a part of the international sentiment on the regulatory regime or on the prohibitive regime against torture. And we also translate into promise domestically for our people, the promise of the Constitution, not to have our mental, emotional, and bodily integrity violated. Thank you very much. Now this brings us to the, okay, there's a question from Vrinda, I think. And what is the question? Well, the question is directed to Mr. Stebrok, and the question is, and I'm quoting, in my view, the promised land is the domestic law against torture and lawyers and human rights activists taking up cases and issues on the ground. The ratification can also have the effect of knocking the issue off the national agenda. India's dismal record on reporting to UN human rights mechanisms and attitude towards human rights are Western persuades me to think that we need to keep the focus on domestic law. Can you please answer this question, Mr. Stebrok?
Thank you. Well, I will try. I think that the question is a little bit like, I think Kennedy was asked, what can the country do for you, or what you can do for the country? It's the same with ratification. It's about what we do with ratification. And I think a domestic anti-torture law is certainly something that we will support at all times. And we have worked in many countries on effective anti-torture laws in multiple different types of jurisdictions. But I do think that the process for eradicating torture is much broader. It's one of mobilization, it's one of institutional engagement, and it's continuous. If we look at our experiences, we see very often, in an ideal case, you have everything fixed and you ratify. But I think very often you move into the room as a forum prorogatorum, as I learned in international law at some point. You move into the room, and then you have your vehicle for which you discuss legal changes, perfectionize the law, for which you discuss with a penitentiary service about what institutional reforms are needed, which will not be something that you will address in a technical law or maybe in a prison law. You will discuss with law enforcement agency, you will discuss with many people. And we have seen that this process of continuous work is one that is central. So it's not whether or not you have to do one before the other. Ideally, you have to have both. You do your law, you ratify. But don't wait forever with ratification, because I think we have seen very often countries ratifying and then working over years on the reform. And finally, maybe in response to Rinda's question as well, something we often forget, the convention and ratification is also a security belt. We always anticipate when we speak about ratification that there's natural progress all along the way. But we see, even in Commonwealth countries, the United Kingdom, for example, is at the moment discussing effectively a law decriminalizing torture in many ways. So it's not a linear process we have. And I think it's very advantageous having the Torture Convention ratified as one of the safety belts if things go wrong, or if there is a momentum that goes the other way around. So it's not only for the immediate improvement, it's also your safety and security belt. And I think it's not one or the other. I think that's a wrong discussion. We want an anti-torture law that is comprehensive in India, similar to some other countries that have done this. But I think the question of implementation on torture is broader than the law. And if I may just add this, and then I'm silent, take the definition of torture, custodial torture that you mentioned. If you look around the world at the moment with these demonstrations and how confinement rules are implemented, there's very much of non-custodial torture as well. And I think this is why ratification is a living instrument, a living tool for the country, which has to be followed up or accompanied with domestic law, but is broader than that. Thank you.
Thank you very much, all the panelists. On this very hopeful and encouraging note, I will have now to close the first session only with one concluding statement of mine, which is that we all know that the progress of human civilization has been a journey from force to diplomacy and from diplomacy to law. And that is why we are now at a stage where we are going to concretize our proclamations and promises to our people in the form of law, both domestic and international, against torture in any form, anywhere, against anyone. Thank you very much, ladies and gentlemen. Thank you very much, the audience, and particularly the panelists. Thank you very much.
Thank you very much, Dr. Kumar, for chairing this session. I am taking over from you as a chair. I'm not as eloquent as you have been. And this has been a very eloquent session by practitioners of the craft, both from policy and intergovernment process and from civil society. I don't want to recap what was said because I am conscious of the fact that we are running quite a bit behind time, but with the agreement of all panelists, we will continue for another 15-20 minutes beyond the allotted 5 o'clock time, if that's possible. But I just want to reflect a little bit on, partly what Ann Gallagher said about the anti-torture car is rather weather beaten. The engine may be functioning, but it is much the worse for wear. And the instrument is beautiful in its simplicity, and it is just something that states should make torture as difficult as possible. And I like to phrase about the new social contract to accept a new standard of relations between state and citizens. Dr. Edwards spoke on the need for best practices, and that they have a whole bank of them, and how they basically enable people, governments to come into the room and have these open conversations and move forward. And the invitation to the government of India that would be, of course, a huge step forward. Ambassador Khan spoke of what I call the golden hour when a person is detained, and the challenges of transparency, and that there's still challenges in terms of work in progress. And Gerald talked about ratification as the first step of the journey, because it empowers. It's really part of the upholding of the sky of human rights, and empowering civil society and governments in this process. This second session has two segments. One is we have 3 speakers. Professor Murthy, the Registrar of O.P. Jindal Global University. Second is Colin Gonzales, who is the Supreme Court Senior Advocate. And third is Henry Defange, Executive Director of People's Watch. And the focus is essentially on the challenges which India faced, which are referred to by Dr. Kumar and a few of the panelists. But we look at different interpretations. I think Dr. Kumar also referred to this at times in his own remarks. The legal process, whether you need a domestic legislation, how is it to be passed, whether there are other ways of dealing with it. Can the cabinet take a decision? What are the other issues relating to institutionalized foundations of torture, which is like not opposing torture, but as I think Ellis Edwards said, that some of the countries where they were laying it out for the police officers, saying that you can't do this is illegal. And even in my own interactions with police, young police officers, they were completely puzzled by the fact that this would be illegal to beat up a person in custody. So normal. So how do we address these different aspects? How do you engage multiple stakeholders? In the audience, there are people like Brinda Grover and others who have done this for a very long time and know it very well. certainly much better than I do. But I think the other part of it is not just the duty holders, but a better informed media, because the media only jumps the gun or jumps to the gun, shall we say, when a horrific case comes to light or a problem or a challenge is raised. And then after the initial hullabaloo, they forget about it. So I think the three panelists will look at this from different perspectives, I know, and I will introduce them very briefly. Dr. Murthy is Professor Registrar of Jindal Global University and Executive Director of the Center of Human Rights there. And he has served in the National Human Rights Commission, including as Director of Policy Research. And he's also a prolific writer. Colin Gonzales is Senior Advocate, Supreme Court of India. Many of us know him by his activist hat, but he's also an activist at court, whatever the court thinks of that particular word. Founder of the HRLN, the Human Rights Law Network, and graduate of IIT Bombay. And although he was a civil engineer, he is now one of our foremost campaigners for freedom everywhere. So, and the HRLN is now 37 years old, which is a few years older than CHRI, but congratulations on that. And Henry Tifange, I think, needs no little introduction. He was a former, he's the executive director of People's Watch. He's one of his key passions is human rights education. He's just organized a terrific human rights education course for over 180 persons from across the country on different aspects of human rights. And he is a former chairperson of Forum Asia and is an executive committee member of the OMCT. And he was, until recently, one of the conveners of the working group on human rights in India and the UN. So we look forward to hearing from all three, and of course Henry is also a practicing lawyer. So Colin, Professor Murthy, sorry, I don't want to make the thing first. Professor Murthy, would you like to go first?
You have to unmute yourself.
Actually, I'll take the opportunity before he unmutes himself to say that, of course, at the end, after the three speakers, we'll have Q&A, and then we have Justice A.P. Shah will give the, as it were, the valedictory, the closing address, the closing keynote for today.
Thank you, Mr. Sanjay. Mr. Justice A.P. Shah, Dr. Ashwini Kumar, fellow panelists, and other participants, warm greetings. In view of the paucity of time, I will briefly flag a few challenges, and maybe I will highlight one or two. One, there is a lack of political will and administrative will to eliminate torture and its practice in any form. Number two, existing mindset among certain sections of the police and certain other sections of the general public that sincerely believes that resort to torture serves a useful purpose. Number three, harmonization of domestic law with the UN Convention Against Torture. Number four, the socio-cultural foundations of torture, the underlying power imbalance which affects the underprivileged groups and communities. Number five, current state of National Human Rights Commission and State Human Rights Commissions. Now, I, for one, having worked in NHRC India for over 12 years, will speak from the perspective of National Human Rights Commission and speak about its role. The NHRC India presents both an opportunity as well as a challenge. Isn't that a paradox? I will explain the context. NHRC India is a category national human rights institution the highest category, fully compliant with the Paris principles, in theory at least. It is a statutory body and is supposed to have a wide mandate, autonomy, independence, and powers. In fact, NHRC is regarded as a pivot in the national human rights protection system. Now, let me pose this question. What can a NHRI do when it has the necessary will, and what happens when it does not have one? In December 1993, soon after the National Human Rights Commission of India was established, the first guidelines issued by it relate to the mandatory reporting of custodial deaths and rapes within 24 hours. Later on, guidelines on videography, model inquest form, etc. were issued. In the early years, NHRC, of course, prioritized custodial violence and torture and must be commended for that. Handling individual complaints of torture is important, but what is far more important is systemic law and policy reform relating to torture. In 1997, NHRC, under the able leadership of Mr. Justice M.N. Venkatachalaya, identified torture as a very serious issue and engaged with the government of India. When it found certain roadblocks with regard to the signing and ratification of Torture Convention, NHRC prepared a comprehensive note outlining social, historical, legal, moral, and other justifications for signing the Torture Convention, and moved the then Prime Minister. As a result of this massive effort by NHRC, the Indian government signed Torture Convention in the year 1997. But in the following years, NHRC has not gone the whole hog in getting it ratified. Year after year, the Commission in its annual report recommended early ratification. What happens when a statutory body is unable to get its recommendations implemented in practice? There will be an erosion of credibility in the public mind, and it will not be taken very seriously by the activists and civil society. I want to give one more instance. In the early years, when confronted with abuse of anti-terrorist legislation called TADA against members of minority communities, environmental activists, trade union members, the National Human Rights Commission engaged in high-level legislative advocacy. The first chairperson of the commission wrote individual letters to each member of parliament, which led to its repeal. So here are instances when you have the political or the necessary will, what a statutory body, how it can make a difference on the ground. And if you look at the Protection of Human Rights Act 1993, under which the National Human Rights Commission was created, it has a statutory responsible for many issues. I will highlight a few of them. It can take up a draft bill or an existing legislation and suggest reforms to the government. It can review international conventions and make recommendations. It can make a special report on any issue, including torture, to the parliament and state legislatures. And if you look at the international system, the UN Human Rights Council also gave the national human rights institutions a big role in the universal periodic review as well as treaty monitoring process. When a watchdog does not have necessary will, it will, in the words of some, become a quote-unquote toothless tiger. A watchdog must be mindful of its role and bark and bare its teeth at times. Now, torture is a very serious crime, and if it is not confronted, it leads to impunity. And in the face of impunity, there is a need for a national human rights commission to take an effective stand. Now, moving forward, I'd like to highlight a few suggestions. We need a sustained and a deeper engagement with lawmakers and policymakers. Legislative advocacy is important. There's a need for creating a parliamentarians for human rights group. We need to identify parliamentarians who are sensitive to human rights issues like Dr. Ashwini Kumar, and they in turn can convince the remaining parliamentarians. The civil society can draft a model legislation and it can be shared with these members of parliament. They can use questions and other legislative tools to draw attention of the government to these burning issues. Political parties can also demand ratification of the torture convention and add it to their respective manifestos. Since ratification is an executive act in India, we must fully engage with all relevant ministries and bodies, including the Ministry of Home Affairs, External Affairs, Law and Justice, Law Commission of India, National Human Rights Commission, and other commissions at the center and in the states. It should be a joint effort between civil society and the executive. Here, the voices and stories of victims of torture could be brought to sensitize the executive. The Ministry of Home Affairs recently launched an effort to reform the criminal laws. So this opportunity can be used with a good effect. We just do not want any watered down legislation. There is a need for a robust anti-terror, anti-torture legislation in compliance with the universally recognized international standards. NHRC can also build a coalition of state level and national level commissions for coordinated action. Media advocacy is important. There's a larger social mobilization in favor of anti-torture legislation involving vulnerable communities and victims of torture is a need of the hour. National, state, and district level public hearings with the participation of torture survivors is an important strategy. We can't pursue torture in isolation and delink it from the death penalty. Prevention of torture is related to the movement for abolition of death penalty. The death row phenomenon, mental health issues in the prisons are all interrelated. The movement for legislation for torture should work with the women's movement and extrajudicial executions, particularly in Manipur, spearheaded by Mr. Colin Gonzales, extrajudicial executions in Punjab, Jammu and Kashmir, and with regard to disappearances, as well as the right to information movement. To conclude, the head of Indian delegation at the last Universal Periodic Review said, I quote, "The concept of torture is completely alien to our culture and it has no place in the governance of the nation," unquote. It is time for walk the talk. It is time to fulfill voluntary pledges and commitments made by India for becoming a member of the Human Rights Council. Ours is land of Gandhi, Gautama Buddha, Mahavir Jain, all of whom are apostles of non-violence and peace. Let us all work together to eliminate torture and its practice. Thank you for your attention.
Thank you, Professor Murthy, for making those very specific points. I was really interested, given your own 12 years in the decade plus in the NHRC, your own thoughts on where it's going or where it's not going, because that is, it is a major issue, and many of us in this room, shall we say, are not just deeply concerned, but wonder how it can become effective at all, in the present circumstances. And I take your point on, I'm not going to say anything more, I take your point on mobilization and so on, but I think in a situation like the pandemic, which is going to continue for some time, it's going to be difficult to see how we do this. How do we get out? Because connectivity is not possible like this everywhere, especially in this country. I'll move to the next speaker. The next speaker is Mr. Colin Gonzales, Dr. Colin Gonzales, Senior Advocate, Supreme Court. Colin, would you like to?
Thank you, Sanjoy. I'll do it rapid fire given the shortage of time. Sometimes I feel that the language we use to force governments to ratify CAT is a language that has been used in the 90s when governments were more amenable to change. Very diplomatic language, very polite language, very imploring kind of language, but all that has changed. And our government particularly has become quite a ruthless government. And language of that kind has no effect at all. It bounces off the back of this hard-skinned, thick-skinned government. To understand the situation in India, as we all do, the situation today is worse than the British. If one were to do a comparison between killings and torture by the police today in India, extrajudicial executions and so on, and compare it with the atrocities done by the British against Indians pre-independence, the study may well show that the levels of violence and torture and so on are comparable. One. Second, we speak as if ratification is going to happen. My own assessment is, with governments like these, ratification is never going to happen. Therefore, when we implore the government to do certain things, and we ask the international community to help us, I think both we and they must wake up to the realization that this government is not going to ratify. And for the simple reason that the police, the most awesome body of organized crime in this country, is deadly opposed to ratification. And they are relentless, and they will not allow ratification in India. Add to this the fact that we saw that in the recent case in the Supreme Court, the judiciary has lost its nerve. The judiciary has no interest in ordering ratification. There was a comment that it would embarrass the government of India, to which all of us, of course, would say that the purpose of doing the case is to embarrass the government of India so that it ratifies. But the judiciary has lost its nerve and the judiciary has lost its heart. So in these circumstances, we must replan and rethink our strategies for getting a ratification of CAT if that is possible at all. So the end result is that in this land of Mahatma Gandhi and non-violence and so on, India is probably one of the most violent countries in the world. And there does not appear anything that we can do to stop it. Perhaps together with the international community, but the international community must jettison its method of discussion and so on, which is not at all appropriate to countries like India, I must say. If the international community wants to have some effect on Indian politics and Indian decision-making, it must radically change its course. Now the question is not why CAT is important. Everybody knows that. And we have spent a lot of time discussing the importance of CAT and so on and so forth, and how CAT will help things change, and the relationship between CAT and Indian law amendments and so on. But that's not the point. That's the old point, 20-year-old point. The real point is, how does the international community, and I would like OMCT and others to take note, please. The question is, how does the international community get an obdurate nation, a recalcitrant nation, a rogue nation? How do you get them to stand up and say, How do you get the international community to stand up and say, listen, there is another way, a more strident way of getting India to accept ratification of CAT, and we must look for that way and find that way today, and not go by the old route that we've gone for a long, long time. How do you force ratification? Now, briefly on the case in the Supreme Court, where the judiciary let us down pretty badly, although it was a good try, but it let us down pretty badly. It focused on the universal periodic reviews, done from 1997 till today. And the universal periodic reviews saw nation after nation telling government of India that they should ratify CAT. And the language used in the statements of the nations were promptly ratify, expedite ratification, accelerate ratification, prioritize ratification. So for 20 years, governments are telling the Indian government, please do this, prioritize, accelerate, etc. To which the government of India very shamefully replies, and this is something that foreign governments must realize, that the Indian government is not averse to lying blatantly, either nationally or internationally. You must understand that about it. And the Indian government reply is supported, not just noted, but supported. So they support resolutions of these countries or recommendations of these countries to promptly ratify CAT. And for 20 years, this drama goes on in the UN in every universal periodic review. Now, the excuses of the government of India as presented before the Supreme Court. First, you must have a law before ratification. If you don't have a law, you can't ratify. And that the United Nations has said time and again. Ratify. And the international community will help you go towards a new law. Will help you draft a new law. So that excuse which government of India used before the Supreme Court is not a good excuse at all. You can ratify first. The UN has no objection to that. You can ratify. The second, that we must have a law. So they said, all right, you must have a law. So we said, all right, you have a bill. First, you had the Congress bill, cleared by all the states, accepted by all the states, allowed to lapse. Then the excuse they gave the court was, we have asked the Law Commission of India to decide whether we should ratify and to draft a bill. And we expected the Law Commission then, Justice B.S. Chavan, to take a pretty long time to ratify, or to make a new law and to say, to recommend it. But surprisingly, he did it in a very short time. And before we knew it, we had the Law Commission report in front of us, a pretty good report. We had the recommendation for ratification, and we also had a draft bill. So we had the Congress bill, and now we had the Law Commission bill. So government ran out of excuses as to why it was still going on and on. Then they said, well, you can't ask Parliament, told the court, you can't direct Parliament to make a law. Now, there's some element of truth in this, in the sense that there's a long line of decisions, Indian decisions, saying that it's not acceptable for a court to tell Parliament what to do, separation of powers and all that. But even that is not correct today. And there are many, many judgments right across the world, from the developed world to tiny Nepal, where courts have found governments out of sync with their international obligations and have directed governments to bring their law, the national law, in line with international conventions. It's not uncommon today. India, of course, remains in the doldrums. We have to shake India out of this. Courts can certainly tell Parliament that you have made commitments in international bodies and entered into conventions, etc., etc. You must bring your law on par with your international obligations. And you have gramophone company case. India must march in tune with its international obligations, and many, many more judgments. Then they said, you cannot direct government to ratify. Why not? Ratification is an executive act under Article 73. Ratification is not a legislative act. It's the second way of making law. It's an executive act. And if it's an executive act, it is subject to the same scrutiny of arbitrariness and so on. So if a court would say that you promised the international community for 20 years that you would ratify, and then you fly across to India and come here before an Indian court and say that no, you can't order me to ratify. Being an executive act, the court could well say, I direct government of India to ratify the convention because it's arbitrary for the government to say abroad that it will ratify and then to come back to India and say we shall not ratify. So these were the contours of the case before the Supreme Court. It was a very disappointing case, particularly to hear the court say that an order directing government to ratify would be embarrassing. It was very, very. And the evidence was so clear that the government of India had lied to the UN again and again and again. And I don't think today countries have any faith that the Indian government is going to ratify. And so with the judiciary gone, or the judiciary not willing to listen to us on this point, the chances of ratification look very bleak. And I want to end on the point that I took up first, because some of our international friends are here. I want to implore them. The international community requires a great deal of stirring, so to speak, to take a different approach and a different stand on India. The lies told to the international community, the control over the police, the control of the police over the decision-making process, and what looks like India's stand of never ratifying CAT. To turn that around, we need to have a different discussion in the future, and we need to have a different arrangement, collaboration, whatever, with the international community, so that India really feels ashamed of what they've done, and we can move again towards ratification. Thank you very much.
Thank you very much, Colin, for that very sharp wake-up call to everybody, because it was necessary, because reality bites, and really bites in different ways, in different parts. And not everybody in the audience or the panel may agree with you, but I take this as a very sharp wake-up call to what exists and what is the challenge before all of us. I'm not going to go any further into this now, but I want to call our last speaker of this panel, Henry Tiffens, to share his thoughts with us.
Dear Sanjay, Justice Shah, and my fellow panelists, let me thank CHRI and UNCAT for taking up this initiative and throwing open into public domain the whole discussion and the relevance of whether ratification has any relevance at all. And it is difficult to call it a need. Hope was attempted to be created by the first panel, and I am supposed to be a very poor replacement for somebody who should have been here. There should have been a member of parliament in my place. The member of parliament could not come here, and therefore I got caught because I was the one who was negotiating with the member of parliament. And the member of parliament today calls me up and says, Henry, what a good day it would have been for me to have spoken, because he is facing and his leader is raising an issue of 2 people who have been killed in custody in Tamil Nadu in one police station yesterday evening. Now, my journey with torture has been a long one, but it has been a long one with the campaigns across the state. And it has been long bringing together a variety of people, including political parties and trade unions and movements, on the streets of the state, not to observe one day as the day of solidarity with victims of torture, not to observe 1 week, but to observe 1 full month for almost 5 or 6 years, with a variety of people joining us from different parts of the state across, with folk artists demanding that the CAT be ratified and demanding that we come up with an independent domestic law on torture. I thought there was an institution missing in this panel. And I didn't know that my good friend Y.S.R. would attempt to replace them here. And I don't and I mention that because to that instinct, the NHRC, which is still alive and which is still supposed to be open. The locks, however, are in our hands to do the act that Colin asked us to do. But while I speak, let me remind ourselves that the context in our country where many of us, including those in the panel here and those who are observing us, following us in the YouTube channel today, all of us are facing daily cases of torture. I have just been thrown out of a suo moto PIL in the Madurai bench of the Madras High Court at 12 o'clock this afternoon in relation to this father and son who were tortured on the 19th evening because they were traders who had broken the COVID rules of keeping their shop open. That's it. That's the great offense they committed. An iron rod inserted through the anus is the forms of torture that was used 3 days ago. No medical examination before producing before the magistrate. The magistrate did not see the two accused, and the magistrate did not refer the two accused afterwards for medical examination. They go to the sub-jail. The sub-jail, I don't know what they have entered. We are still to get documents. They also did not refer him to the hospital. In 2 days, the son dies on the 22nd evening. The father is immediately rushed to hospital at 10:30 in the night, 5:30 in the morning yesterday. Our judicial district, the police, and unfortunately the jailers are in a silent conspiracy in this case. And it will continue. All political parties are on the street today. But that is a daily incident. This is what is happening day after day in our situation. I have cases in my own city where for the past 2 years we are fighting different cases. And mind you, in most of these cases, my dear friends, we find that we are not able to proceed because the witnesses are bought over, victims are paid compensations, illegal gratifications of up to 17 lakh rupees, as a result of which, even when cases are pending in the High Court, they are withdrawn and the High Court throws us out because there was a change of wakalat and you cannot come or enter into the shoes of the victim once again. This is the shameless battle that we are fighting on the ground day after day. We make small gains here and there. We talk a lot about those small gains. We do public hearings. And right as I'm speaking to you now, my good colleague, my good friend, and perhaps one of the persons who has handled the maximum number of torture cases in the country, Kirti Roy of Masum, is on another 1 week long campaign towards the observing of the 26th of June. We both were accused by the Kolkata police for doing a public hearing in 2008 on torture in Kolkata. It took us almost 10 years for the case to be dropped. It was he who was arrested, not me. I had the luxury of being from Tamil Nadu and therefore the luxury of not knowing that I was an accused there because I had no formal intimation. And that is what happens not only to the victims of torture, but to people who strain their nerves like Kirti Roy to stand with victims of torture and ensure that it is combated. Friends, we have had a number of experiences, let us not get into it. But the moment torture takes place, the first hurdle is the medical examination. and all the complications that arise in medical examination. Now you have the amended CRPC with the 176 1A inquiries that take place, secretive as they are. The reports are not seen in public, and therefore, even if those reports conclude that there has been torture, the torturers are no longer challenged with private complaint prosecutions that used to happen in the past. There is no victims and witnesses protection scheme of 2018. NHRC, 27 years, compensations. Not a single prosecution in 27 years can the NHRC boast about. Where will impunity be fought? Yes, I love this example of Tada and Pota. We threw Tada out because there was a campaign mode within the NHRC to do that. Even when Justice Verma initially supported Pota, Justice Verma was humble enough to listen to what the colleagues in the NHRC had to say and then had a resolution against Pota. But for torture, nothing. The National Legal Services Authority, and this is something we have to question, under Section 12, has one of their clientele who's supposed to be people in custody. And there is nothing done today for people who are tortured in custody, people who are killed in custody by the National Legal Services Authority or the State Legal Services Authority or the District Legal Services Authority or the Taluk Legal Services Committee. I come from the culture of Tamil Nadu Free Legal Aid Board, where the cases those days when I was a very young lawyer was Tamil Nadu Free Legal Aid Board versus State of Tamil Nadu, before the Legal Services Authority Act came. The government of Tamil Nadu, during the leadership of Dr. MGR as the Chief Minister, cut the funds for the Tamil Nadu Free Legal Aid Board because they were taking up cases of torture and custodial death. That is the culture of the Legal Aid Board. Today, that is another institution which is remaining totally silent to such issues where they can easily act. Human rights defenders who stand are penalized. We are losing our dignity with all these institutions because we are always seen as troublemakers on issues of torture. And therefore, friends, it is now we have one major role that the National Human Rights Commission should have done, which was to follow the 2005 reference on torture by the Advisory Committee of Jurists of the Asia Pacific Forum of National Human Rights Institutions, and I'm sure Mr. Y.S.R. Murthy will remember that, where Mr. Farin Aliman was a member of the Committee of Jurists at that time. And they came out with a reference on torture. And I'm not going to get the reference, but I'm going to go to one aspect of the reference, which was called the minimum interrogation standards. They set the minimum interrogation standards and called upon member states, members of the Asia Pacific Forum, which is the National Human Rights Commission in India, to insist on the implementation of the minimum interrogation standards. And if those 27 standards are followed, then you can have a little bit of ease in the methods by which interrogations are carried on today. But that was also not followed by the NHRC. And today, we're talking about ratification. Weeks ago, if I'm wrong, Sanjay will correct me, in its midterm report on the UPR, Colin rightly referred to the 2008, I think the 2012 and the 2016 UPR recommendations on torture. The 2012 had 41 countries recommending, not one or two, 41. And this NHRC midterm report on the issue of CAT ratification has the following to state. As the government of India has accepted the recommendation to ratify the CAT in the present as well as previous UPR cycles, it remains committed to ratify the said CAT. Lovely assertion by the NHRC. Toward this end, the government of India has requested the Law Commission of India to examine and give a comprehensive report covering all aspects of criminal law so that necessary amendments can be made to the Indian Penal Code, to the Criminal Procedure Code, and to the Indian Evidence Act. My dear friends, all the listings of tasks that the government of India had done were beautifully portrayed before us. And now we are taking steps backward We are not even talking about an exclusive domestic law. Ratification has gone very far away. But even on the question of domestic law, nobody has the guts to talk about a domestic law. They're talking about amendments to the CRPC, amendments to the Evidence Act, and amendments to the Indian Penal Code. My dear friends, it is time for us to come on the streets once again with our campaigns, but our campaigns with political parties. And when I say this, I say it with great respect. Political leadership of the caliber of Mr. Ashwini Kumar themselves, when in power, could not bring a domestic law on torture. That is the reality. It is after they were out of power that they had to move the court of law. And therefore, it is important that political parties are brought into this campaign. Trade union and movements of people across the country come unitedly to ensure that we are all part of a larger campaign for a domestic law on torture. And of course, simultaneously asking for ratification. But the shaming game has to continue using our international mechanisms. That is what pays. And the one proof that you may have in this country that it pays is the fact that I remain here for 2,000 days with my bank accounts closed because I'm accused on affidavit by the Ministry of Home Affairs that I communicate with UN special rapporteurs. So if there is a proof that is required that this country is sensitive and can be shamed using the international mechanisms, I am one concrete case with an affidavit filed by the Ministry of Home Affairs. For 2,000 days, my FCRA, my bank account is still closed and I'm still before the court with an affidavit saying I communicate with embassies, I communicate with the UN special rapporteurs. And therefore, our country will be taking cases, but we will continuously communicate with all the UN special rapporteurs, all the treaty bodies, continuously putting pressure on this country that therefore they will have no other go but to domestically come out with the law and ensure that ratification is possible. It is our failure that we have not unitedly continued on the campaign mode that we are supposed to do. Dalit movements should be there because those who are tortured maximum are Dalits, tribals, and the Muslims in this country. Persons with disabilities are tortured. Women in the country are tortured. We all need a united campaign on the streets of our country for carrying on this mandate. The courts are important. We will continue to fight in courts, but we will let the courts know that we will raise our voices outside courts and put pressure on the courts because that is the way to put courts back into place. Let us not forget that the senior counsels of our Supreme Court could bring back the Supreme Court into action on the matter of migrants recently. Thank you.
Thank you, Henry. Actually, I'm just conscious of the fact that we have allotted 2 hours for this panel, but this should really be something we go over 2 days because there are not just contesting points of view, but there are such rich issues, such difficult issues that we have to converse and come to conclusions about. It's very difficult to really handle this in the space of an hour or an hour and a half and so on. But I thank you for those very forthright remarks and the problems that all of us face, the challenge of really being able to walk the talk in these situations. And you and Colin and Professor Murthy have set a fine example. What I would like to do is, I believe there are a couple of questions. I want to just open it up for questions and then we'll move seamlessly to Justice Shah, who's been waiting very patiently for his remarks. So I understand there are a couple of questions. Could I think they've been sent to, have you received the question to Professor Murthy? Have you received your question?
No.
If you haven't, I'll tell you what it is. The NHRC UPR midterm report says this about CAT ratification. The government of India has accepted the recommendations to ratify in the present as well as previous UPR cycles, remains committed to ratifying the convention. Government of India has requested, as Henry read out, the Law Commission to examine and give a comprehensive report covering all aspects of criminal law, what he was talking about in terms of the IPC, CRPC, and Indian Evidence Act. So the question is, this is factually incorrect. Perhaps Professor Murthy can respond.
I'm no longer with the National Human Rights Commission, having left about 11 years back. And
no, I think she was talking about the issue of the specific point.
Yeah, see, the very fact that UPR 1 cycle, first cycle, the serious recommendation was made by many states to the government of India to ratify the torture convention, and it was not done. And then the second cycle passed, and the third cycle passed. It's a reflection on the credibility of the international human rights mechanisms. It casts a long shadow on the effectiveness of the UN Human Rights Council itself. And NHRC could have taken a better stand in the light of the prolonged reluctance, or like 3 cycles is quite a long time. When a promise was made in the first cycle of UPR, and also when voluntary pledges and commitments, you can, in fact, the convention was signed in 1997, and it's nearly 23 years now. And the ratification is nowhere in sight. And so the NHRC could have taken a more proactive and more, and it could have, as a watchdog, it could have made its stand known, and it could have asked for the early ratification, and it could have done many, many other things. As I said, it has a range of tools open to it. It can, it can send shadow reports to the various treaty bodies like Human Rights Committee and Women's Committee, Children's Committee, and it could have, the Human Rights Council itself has given a large role for participation in the UPR process and in the process, in the monitoring process, and many others. So NHRC could have utilized the various range of powers open to it. But it has stopped short. It has just accepted the government position, and nowhere in sight. And the ratification, maybe.
I think we'll have to, there is another question, but I'm just conscious of the time. And there are 2 things I'd like to say here. One is that this is, I feel the need, this is the time when I feel the need when people can get together for a face-to-face conversation and a discussion. The webinars are a good forum, but it can go only so far. Like, if we were in a room and actually engaging with each other, there was much more opportunity. There would have been much more opportunity for moving to a particular point, And that is one thing. The second thing is that our colleagues who are in Geneva and elsewhere, Gerald and Alice and Ambassador Khan, I'm sure you see the, shall we say, the challenge within the system, the challenge to the system, the challenge within the system, because I don't think there is anything called what Professor Murthy talked about, the political will doesn't exist to do it. Actually, the political will exists not to do it. That is the crisis. So, and I think everything happens because political will drives either for or against a certain process. Sorry, did you want to comment?
I wanted to add one more point. Basically, the state of health of the national and state commissions is poor, and there is a need for building their capacity, particularly including at the senior most level, the chairperson, members, and at the official level. There's a lot more sensitization that needs to be done, particularly for those who join the commissions as a new members, so that they understand their mandate well and then discharge their mandate.
question always is who's going to do that training? Who will train the trainers? I'm afraid we have to move on. Thank you, panelists, for very forthright comments, very, straight from the shoulder, no holds barred. And, we are still groping for answers, really. We don't really have a sharp, clear focus on how we can go forward. There are ways we can go forward, but it's not precisely clear because, for instance, I would have liked to have heard from all of, Henry and Colin feel that I think that the amendments are certainly not the way. Should we take something that is like halfway or 1/3 of the way, or do you want to go in for a full thing like a domestic law? Those are issues perhaps we should have another conversation on this, specifically on that, and I'd like others like Rinda and others to come in. Now, thank you all very much again. I'd like to ask Justice Shah to speak to us now. Justice Shah, as we all know, is the former chairman of the Law Commission, former Chief Justice of the Delhi and Madras High Courts, one of the most distinguished jurists we have. We are also very privileged that he has been a board member of the Commonwealth Human Rights Initiative, the India Board, for several years. And since 2011, he has been the chairperson of the Broadcasting Content Complaints Council, which is the self-regulatory body for non-news general entertainment channels set up by the IBF, which is the Indian Broadcasting Foundation. And we look forward very much to hearing his remarks. Thank you, Justice Shah, for your patience, and please do come.
Good day, everyone. Can you see me?
Yeah, we can see and hear you. Fine. So please go ahead. We can see you and hear you fine. So please go ahead.
So good day, everyone. It's an honor to be present here today to speak on the prevention of torture and similar atrocities, which is something I feel strongly about and have been involved in for many years. This is an opportune time to be speaking on the subject of prevention of torture. It is barely weeks after George Floyd was killed in Minneapolis after a policeman held him in a chokehold for 8 minutes and 46 seconds. While that incident has spurred the global Black Lives Matter movement, for us in India, it should serve as an occasion to introspect. Even as some intellectuals express solidarity with the movement, arguably, I believe that this reflects the hypocrisy latent in ourselves, where homegrown methods and practices of state-sponsored or state-endorsed torture are routinely used to target minorities within the country. Racial and community biases are inbuilt in India, just as they are in the United States. For instance, when news of the Chinese origins of COVID-19 came about, Northeast Indians were the first to be targeted. Similarly, when the Tablighi Jamaat event in New Delhi led to a host of virus cases, the community was ostracized. With this contemporary reality, merely expressing solidarity with or protesting against the goings-on in a foreign land without recognizing or attempting to remedy the truths within is really not something I find compatible with. Take, for example, the recent Delhi protest, where protesters against the Citizenship Amendment Act, which is unconstitutional on the face of it, in my opinion, were systematically persecuted against using provisions of the Indian Penal Code pertaining to rioting and unlawful assembly. While these are already questionable grounds, These protesters were also slapped with charges of promoting enmity between classes, Section 153A, sedition, Section 124A, and criminal conspiracy, Section 120B. These are all draconian provisions. And given that most of the protesters were of the Muslim community, these charges reeked of a clear inbuilt institutional bias in law enforcement and prosecution. In contrast, no action was taken in response to many inflammatory speeches in the same context made by politicians of the ruling government. The activist Khalid Kaifi, for example, appeared in court in a wheelchair with both his legs in cast, clearly pointing towards custodial torture. But the judge failed to notice this. But it is not just Muslims or other minorities who are targeted. Indian criminal provisions are routinely abused to scare tactics to deter genuine dissent, as in the recent case of criminal conspiracy slapped against the activist Harsh Mandar, which is especially shocking considering that he has always come as a man of peace and human rights defender. Instances of state-sponsored or state-endorsed torture abound. And if one were to start, we would have a litany of cases to talk about. Some years ago, I was asked by an organization called the Innocence Network to be a part of its first People's Tribunal on Acquitted Innocents held in New Delhi. The jury I was a part of heard the testimonies of those who had been charged with terror crimes and had been acquitted. The objective was to create a framework for compensation and rehabilitation for victims of wrongful prosecution and conviction in India. The general theme of the testimonies was of lives destroyed by years of wrongful incarceration. What troubled me much more was how such instances of illegal and wrongful detention were compounded by torture in police custody, forced confessions extracted under duress, and an unrelenting criminal prosecution process that repeatedly denied bail to them. The many testimonies before us showed that torture is just not an integral part of India's policing culture. In terror investigations, especially, it is treated as the centerpiece. Why this is so is a complex issue. It is partly because the law is designed as such. For example, admissibility of confessions as evidence under the Terrorist and Disruptive Activities Prevention Act and the Prevention of Terrorism Act, previously which continues to persist under the Maharashtra Control of Organized Crime Act. That police torture is endemic to India is not unknown. Official data shows that some torture persists in India, but the accuracy of such data is questionable, as the source is the government and its agent itself. The more compelling case for police-supported torture is recorded in reports made by NGOs and observers over the years. Notably, the Torture in India report by the Asian Center for Human Rights, 2011, the India Torture, Rape and Death in Police Custody by Amnesty International, 1992, the report on torture and impunity in India, National Project on Preventing Torture by People's Watch in 2008, and the Crimes of Habit report by PUDR in 2014. Even as official data is problematic, the official position on torture is also troubling. In 2017, India has presented its case in its third Universal Periodical Review, and a statement by Attorney General Mr. Mukul Rohatgi was referred to by Mr. Murthy. So in his opening statement, he invoked Gandhi, Buddha, stating that India believes in peace, non-violence, and upholding human dignity. As such, I'm quoting his words, as such, the concept of torture is completely unknown to our culture and it has no place in the governance of the nation. The hypocrisy in this statement cannot be overemphasized. It's not a promise. It is a complete hypocritical statement by the government in the periodic review. This is the same country where in a rape and murder case in Hyderabad, 4 accused persons were killed in a supposed encounter and their deaths were publicly celebrated. A commission was appointed by the Supreme Court, but 6 months on, no action has been taken against the police. Indeed, routinely, even where courts awarded compensation in torture cases, no disciplinary action is taken against the police. The National Human Rights Commission is according to me, it's a completely dormant body and has never pressed for action against the officer guilty of torture. I will give you a shocking example of this. A Muslim young man was killed by the police in custody, and a petition was filed on which the Bombay High Court ruled in 2004 that the officers, all concerned officers, should be suspended, and there should be disciplinary inquiry against those officers. In 2020, after 16 years, without holding any disciplinary inquiry, all 4 police officers have been reinstated. The mother of the victim has again approached the High Court for redressal because no inquiry was conducted. Sadly, it is not just the statements of functionaries of the executive that are disturbing. In multiple conversations, I have heard many high-ranking judges say that torture is necessary for law and order. Some are convinced that without torture, evidence gathering and successful prosecution and conviction are just not possible. This openly public denial of torture and closely guarded police practice and acceptance of torture as a necessary social evil in India has been termed as a public secret by one commentator. This is compounded by the disclosure of the so-called war on terror, where any treatment meted out to certain communities is par for the course in order for law and order to prevail. This has effectively endorsed and stealthily legitimized the use of torture against certain communities, notably Muslims and many other poor and vulnerable sections. This is sadly the reality of law and order today in India. The public secret and official perception on torture rest uneasily with Supreme Court's jurisprudence on the issue. In the Raghubir Singh versus State of Haryana, the court, and I'm quoting the court's word, was deeply disturbed by the diabolical recurrence of police torture, resulting in a terrible scare in the minds of common citizens that their lives and liberty are under a new peril when the guardians of the law gore human rights to death. These sentiments are revisited in Francis Mullin versus Union Territory of Delhi and Sheila Barses versus State of Maharashtra, where the court condemned cruelty and torture as being violative of Article 21. I request all concerned to go through these and similar judgments. This interpretation of the Supreme Court of Article 21 is a remarkable achievement and is consistent with the principles contained in the UN Convention on Torture, or the UNCAT. You'll be surprised to know that even the definition of torture, which includes mental torture, was accepted by the Supreme Court in its jurisprudence on torture under Article 21. In this context, the status of the law on prevention of torture is important. As previous speakers told you that India signed the UNCAT in 1997, it is yet not ratified. In 2010, a prevention of torture bill was tabled in Parliament and passed by the Lok Sabha, being a weak bill. In fact, it was supporting the torture rather than reducing it or dealing with it. And it was sent to select committee for review. Mr. Ashwini Kumar headed the committee, before whom I deposed as well. The committee earnestly tried to revise the bill, and at least 2 alternative drafts were offered in the depositions. But the recommended law of the select committee, which was submitted in 2000, never ratified. The bill was simply allowed to lapse by the UPA government then in power. In 2016, a petition was filed by Mr. Ashwini Kumar seeking a torture law compliant with the UN Convention. By 2017, the Law Commission had submitted 273 report and an accompanying draft law. So there is a draft law made by Law Commission. See, Mr. Ashwini Kumar filed a second petition. I'll just deal with the first petition, where I have a serious issue, the way the Supreme Court acted. And Mr. Upendra Bakshi, in his a very fine article, said it's a great betrayal of the people of India. The Supreme Court, without any regard to its own jurisprudence, unfortunately dismissed the petition on 3 grounds. The government cannot be compelled to make a law by amendments. TT ratification was a political decision. It was a policy matter. But this rejection was in complete contrast to what the Supreme Court has done for lawmaking ever so often in the past. Whether in the matter of sexual harassment in the workplace, the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, and the Vishakha case. In Vishakha case, the Supreme Court drafted a law and asked the government to implement it till the government comes with till the parliament passes a proper legislation as under CEDAW. Or say customary international law brought into Indian jurisprudence, especially the environmental law, the right to privacy, the foreign adoption. The list is long and varied, and revelatory of a proactive code that sees its role as an arm of the state responsible for, as Mr. Bakshi described it, nudging a slow-moving legislation into quick action. That is what was expected. This is what Mr. Ashwini Kumar said. That nudging function, even that was not performed by the Supreme Court. So however earnest the cries for enacting a torture law in India might be, the truth is that the powers that be do not want such a law to come about. The first version of the torture law lapsed under the UPA government. A second version, based on the version drafted by the Law Commission, was played around in the regime of the current government in the previous term. The Commission's version was, although substantially in line with the 2000 Select Committee's version, some key differences are there. I will just broadly tell you about those differences. The 2010 bill defined torture broadly to include mental agony and trauma alongside mental pain and suffering. This is accepted by the Supreme Court as a torture violation of Article 21. And torture in the context of discrimination based on sex, race, religion, and included an list. And this is a bias against the minorities and certain communities so rampant in the police force. So this was therefore this particular provision was made by the Select Committee. But these are all missing from the first version, the Law Commission's version. And the another thing which is missed is the limitation, and the 2010 recommendation was 2 years, 6 months. But the last important aspect is there is a deeply ingrained culture of torture in the policing system. Means that higher ranking officials have a greater than usual involvement in torture incidents, but also to tend to get away with if there is any prosecution. Mostly the junior officers are made scapegoats. So therefore, there was an idea suggested of command responsibility, but it's not there. Even with its findings and limitations, the Law Commission's draft bill is better than not having a bill under consideration at all. While this version was circulated to state governments, they say it's their response is awaited. This one more aspect which I would like to put before you. I heard a lot of discussion on whether it should be only ratification or it should be with a domestic law. See, this is not a good strategy to now say that only ratification is sufficient, though I'm very certain that this government is not going to even ratify the bill. the ratify the convention. So if on the other hand, I sincerely believe that you are actually giving the government an escape route by simply ratifying the convention and thereafter not making any law. See, the question of whether there should be a standalone law or whether there should be amendments to the existing law has been considered by practically everyone, the parliamentarians, by the law commission, and the consensus is that there should be a separate law. And I hope that we should still pursue that line. I believe that there is no way in which Home Ministry or indeed the government can be persuaded to take up the law with enthusiasm. State consultation also has no meaning in the present political atmosphere. But as like Mr. Ashwini Kumar, I am also an eternal optimistic. The situation seems to be very disheartening, but I also believe that all is not yet lost. So what can be done instead? We can start with advocacy among the younger members of parliament. Please, I mean, invite them, have dialogue with them, not as a human rights forum, but generally engaging with parliamentarian is a completely we will have to form a strategy for that. We can seek out the NHRC, which is and I don't hear, I mean, most of as a law commission, in the law commission, whatever we conducted, the hearings, public hearings on certain issues like death penalty, etc. The Human Rights Commission never appeared before us, in spite of invitations, in spite of telephone calls. Nobody came from NHRC, and so we had to do something to ask it to perform its advisory role. It may be only advisory role, but it has to perform with greater vigor and sincerity. We can go to law colleges and educational institutions and tell them about the truths of police brutality. While all states may not be approachable, I understand that. Advocacy with some states' government might just work favorably. Even talking to police academies. I mean, this is one I honestly believe, that don't be under presumption that all policemen are bad or they are prone to brutality. It's not correct. And the most important is the modernizing policing itself. Police reforms in some way is the key. This will have immediate benefit. One of the reasons why torture is still used as a means to elicit confession is because policing has not mainstreamed the upgrade to newer technologies like DNA analysis, and there are various other technological advances which can be directly impact law enforcement agencies. So we can also make an attempt from that angle, talking to the police, which CHRI has been doing for the reforms in the police, and that's very earnestly the CHRI is attempting to talk with the police. In sum, while the situation around the bill immediately seeing the light of the day may seem hopeless, I'm personally still hopeful of other ways in which stakeholders can be influenced to change their minds and behaviors, and perhaps that is the approach we need to take to bring about the change we seek. Thank you very much.
Thank you, Justice Shah, for those very elaborate and very detailed and very thoughtful reflections which come from a lifetime of observation and service and experience. So deeply appreciative, and all the entire program is being recorded, so we will be making excerpts of your remarks also available to a wider audience. We've had nearly 100 people watching this webinar so far on YouTube, and hopefully more will watch it later. And without dwelling on the many very powerful points you made, which shored up essentially some of the things, the challenges that we face in the system, dealing with the system in this time, at this age, and also at the previous time. There's, systems don't change. It's basically, if there is a change to be brought about, it has to be brought about from without as well as within. Before I hand the mic, shall we say, to Gerald for closing remarks, I'd like to just thank a few people for their very hard work behind the scenes. So that's Alice Vieira, who's been in touch with each one of you consistently, persistently, and perhaps, bothered you extensively over the past many days. But we are able to come together largely because of her persistence and commitment to the cause and her dedication. So I'd like to thank Alice and her colleagues Aditi Patil and Sarthak Roy in the International Advocacy Program of CHRI.
power bank देने के लिए आज जो लाया है वो power bank.
Ajit Mishra, who's our technology person, for bringing this together. All our resource people, of course, Dr. Alice Edwards, Gerald himself, who's going to speak, Henry, Colin, Professor Murthy, Ambassador Khan, Ann Gallagher, who had to leave. So to all of you and Professor Dr. Kumar, so to all of you, my thanks, and also to Stella Anastasia of the OMCT in Geneva, who worked very closely with us to bring it all together. So I'll close here and hand it over to you, Gerald.
Thank you, Sanjoy. I think you put me in a very difficult position after listening to all these very learned, very, very, very sober, very interesting, very rich contributions. I may be too young to say this, but I start with an anecdote in my final word, which is at my graduation ceremony, you had lined up all these celebrities speaking, and the last one was Roy Lichtenstein, the pop art artist. And we were all waiting for his speech, and he came to the podium and said, after listening to all the speakers previously, anything I would be saying now is completely ridiculous. And he left the stage. And I feel I'm a little bit in a similar situation, that after all these speeches and all these contributions, it's very difficult for me to say something that is not ridiculous at the end. But what I would like to do, because I'm not Roy Lichtenstein, so I'll probably have to say a few words, I would like to thank everybody. I would like to thank the Commonwealth Human Rights Initiative for initiating this and for convening this, and for making it possible for us to, by a distance, to be with you in this discussion. And I'd like to mirror what you said about all the speakers, and the thank you for that. What I take out of this discussion is the first point, the mere fact that we speak about ratification, that we speak about an anti-torture law is good, because the issue of torture needs to be back on the agenda. And we sometimes, even in the human rights community, forget how central the foundational notion on torture prevention is, and how much it is a disease that goes into other areas of our societies. So I think the first point I really take is an encouragement that these type of meetings and a discussion on ratification puts torture back on the agenda where it belongs. Now, I think it is important for us to keep it on the agenda and to drive that agenda. And I think I've heard a lot of different interesting ideas in this. One of the points that I think is very important, ratification is not an abstract goal. It sounds abstract. Like the prevention of torture sometimes sounds very abstract. There's a chanson in French. I speak about love like about a car. I sometimes feel we speak about torture prevention like a car, something abstract. So what ratification, torture law, anti-torture laws have to contribute to is helping victims, helping the survivors of torture, having addressed the problem. And I think this leads also to the question, how do we mobilize on this? I believe that there are different layers that came out of this meeting where mobilization and coalition building is needed. One is, and I think centrally the local one, the torture convention ratification makes me happy, but that's not the purpose of the debate. The purpose of the debate is that it has value in India. And I think it needs a coming together, coalition building, different communities to say, something is wrong, something needs to be changed. We need accountability, we want accountability. And I think this is one of the elements that I see. But I also see that in this broader movement building, there are different actors we need. The National Human Rights Institution was mentioned in successful campaigns for ratification or for national human rights laws or anti-torture laws. We've seen in other countries that they take a key role in bringing government and civil society together to move this forward. So we need that level of leadership, I think, in India as well. I think, although the times might be changing and it might be from the old days, I sometimes have taken encouragement from a law in the United States, the Anti-Torture Act there, which came about not by the democratic governments, but under Ronald Reagan. I think we have to make sure that human dignity is not in the provenance of one political party, but that we bring people together on values together. This may be very difficult, but I do think that when we see the Torture Convention or an anti-torture law or other anti-torture agendas, we see it as agents for change. I think then this discussion is one that is important. We hope that it concludes, at the OMCT at least, we hope that it comes to conclusion with ratification, because as it was mentioned, repeatedly now we had the pledges for ratification by the Indian government with concrete time frames accepted before the next UPR review. We had this repeated when India joined the UN Human Rights Council. So I think it is important that that international level continues to push as well and to be part of the equation of this broader movement building against torture, with a ratification as one of the aims in its process. It was mentioned in the beginning that it is a journey. I like the idea of a journey, but I also think that journeys need to be targeted. They need to know where the journey wants to go. And I think it is our role to guide that journey, maybe through more discussions on strategy and how we continue pushing for this, how we continue engaging for this. But I'm encouraged from these discussions, from everything that I've heard. I found it extremely enlightening. It's an experience I will take with me elsewhere. But I hope it's not a curse, but something positive. In German, we say, there's always a second time in life. I hope we continue this journey, and there will be a second time soon to continue this discussion and to see what on different levels we can do to drive it forward. Thank you again very much for joining. This is the UN Day for Victims of Torture on the 26th. I hope you all will be ambassadors on this issue on the 26th. And my real thanks, or my full thanks, goes to Sanjay and his team, who have done an amazing job on this, as they've done for years and years. Thank you very much.
Thank you, Gerald. And I think we can wrap up now. The only thing left for me to say is that let's continue the engagement and let's continue the mobilization, the conversation, because everything, the journey proceeds this way. Because nowadays we can't make real journeys, we have to make virtual ones. So this too can be a journey virtually and in reality. So thank you all, and thank you to everybody for joining us. There will be a recording available, and we shall make it accessible to everybody. Thank you, OMCT, thank you.